a person who files a counter yesterday or day before has omitted to mention Hamlet in the Prince of Denmark or Prince of Denmark in Hamlet. But this is his complaint, it's a foundation. Till now we don't know about it. Your Lordship doesn't know about it. Realizing that he is apparently curing the governor's defect, but not realizing that the governor doesn't tell your Lordship whether he's acting on this complaint which I have read just now or the 31st July complaint. It is quite unclear. He has not, well, why should I not say that he acted on the complaint I have read to your Lordship and not on this? Why should I not say it? And why is it not fortified by the fact that the first time this has been mentioned is on the 29th of August in the middle of arguments? Well, it's 31st July. When did I argue the matter first? I argued it 1 week ago, I think. 19th August, 31st July, 19th August, 29th August. In between on 27th and 28th August, counters are filed. Well, there are 4 occasions. I'm sorry, Balas, I'm making a little...
No, let's see whether the omission would cut at the root of the matter.
It would, Balas, because this is a Balas, your Lordship takes a holistic view. No single straw breaks the camel's back. But Balas, this is very, Balas, to put it in the mildest word, is strange is not a good enough word, Balas. This is amazing. And even taking this letter as it is, we do not know on what the governor acted. We are on the, ultimately, governor's sanction must go. Governor's sanction must go for all these reasons. We have no idea what he acted on, apart from, of course, never sending us a show cause. And that point I had made last time without knowing about this letter.
So you have to say that on this he asked for sanction. Just read this. On this 376 he asked for sanction. Now he is getting intelligent and saying what? Just read.
Now, Malas.
But one...
Let me go.
One clarification.
Yes.
17A, does it contemplate issuance of a show cause notice against whom sanction is approval is sought? Does it contemplate?
Well, it's
application of mind will consider, but the submission that you're trying to make is governor has referred to these two and show cause notice was not issued.
It was issued.
No,
also
only against one
the
complaint.
Principle of issuing R3.
R3 is
the principle of issuing show cause is accepted by the governor himself.
No, true. But whether law requires is what I'm...
Therefore, Malas, I would say yes. Natural justice. Your Lordship now, Malas, has... Malas, let me digress for 2 minutes. For the answer, I'll be dealing with it separately. Let me digress. This is a direct question from the bench. I'm obliged to, Malas, digress for 5 minutes and answer.
Yes.
Well, it's not now, but from 1967. Your Lordship has this felicitous phrase, adverse civil consequences in
Yes.
Bina Pani Day.
Yes.
And your Lordship did not have very big constitutional principles in 1967.
Yes.
When your Lordship elevated saying, all this quasi-judicial, judicial, administrative, we go by adverse civil consequences. That is 67. Now, Malas, your Lordship has travelled a distance, 2 recent judgments, one of which I had the privilege to assist the court. That even, this is exactly the same argument raised, Malas, that before you declare an account fraud, not Malas NPA.
No, fraud.
Fraud.
That has serious civil consequences.
This
Notice has to be there.
No, the argument was to declare it as fraud is like filing an FIR. You don't need a show cause. There is a specific argument to Solicitor General who opposed me. It's recorded.
That is...
Now, the FIR, you don't require a show cause.
No, FIR you don't require a show cause at all.
The argument is that before you declare criminal fraud, an account beyond NPA, you don't need natural justice. And the people in that batch, which we argued, Balas, were apparently allegedly owing hundreds of thousands of crores. The court set aside a batch on the principle of natural justice. My answer to my lords, respectfully, is that natural justice is now elevated to an Article 14. It's now part of Article 14, which is not earlier. Today, Malas, when you do something with very serious, the most serious adverse civil consequences, you are granting sanction to a public servant, in this case, the highest public servant of the state. No.
Oh, sanction is also mentioned.
No. Sanction, oblique approval, let us call it. You are granting to the highest executive of the state, and you are yourself treating as show cause relevant, but you forgot to talk about the other guy. You did have Malas relevance in the first chap. Therefore, Malas, you should have dealt with it. On balance, as of today, the law would, Malas, be interpreted in my favor. But here, Malas, I'm on something else. To come back to the point here, Malas.
No, I thought it fit to ask you that for the reason that no notices were issued on these 2 complaints is what you said.
Malas,
that's the reason.
The reason is this.
Yes.
That he felt that he had issued one. Malas, the reason is hurry and lack of application.
That's fine. Yes.
That's the real answer.
That
Let us be practical. Well, the real answer is that.
Yes.
I got a complaint. I must proceed. So I issued notice of that complaint to him. I got two more. I said, I've already issued a notice for one. I don't bother about all these technicalities of law. Let me pass the order as quickly as possible. That's what has happened.
All right. Well,
But Balas, I must now come back to this. This is
yes.
very, very interesting.
I wanted clarification.
No, I'll be dealing with that. I'll cite Dharampal Satyapal and Rajesh Agarwal. I'll
Yes.
cite those two judgments. Because the court has gone very far there on natural justice. Telling your lordships how important it is. Therefore, there are three, one more thing I want to say on natural justice before I come back to this. There are three categories. Category one is the category where expressly the statute excludes natural justice. There are many statutes like national security, atomic energy plants. Your lordships there alone. The second category is where you expressly include natural justice. There is a third category which is the most interesting. The silence of the statute. Your
Then we will have to read into the statute.
In Maneka Gandhi, your lordship quoted the very nice words of Hooper versus Wandsworth. The common law will supply the omission of the statute. That's the principle. In the interstices of that gap, you will read in natural justice. And this is, whereas nobody can doubt, is the most serious of adverse civil consequences. So you must read into this. Here the governor has acted on that basis. Only that he has not issued show cause notice on X and Y, but he has issued on Z. So there is no question about it in this case. But let me come back to this intervention by Mr. Raghavan just now.
Yes.
Well, as your lordship will see the number of occasions and how strange this is. You have now, just now told your lordship that I did apply for sanction. Right,
Yes.
And this document which Mr. Singhvi is reading is of course not the sanction because I'm reading a document that doesn't seek sanction. Now, this document I read just now, I didn't read one and read in Kannada,
Yes.
is actually attached to the objections, right, Wallace?
It is.
Now let us see what the objection says. It says this is the application for sanction. This is the problem. When you make up the story as you go along, the problem is this, Wallace. Truth has a very strange way, Wallace, of getting you caught up in all kinds of webs. Now let's come to para 55. That was the intervention 2 minutes ago. Now you should see what your deponent has said.
Para 55.
Yes, page 43.
Mm.
43 of what? Sir?
PCR, what is PCR?
Objections.
Private complaint filed here. Before trial
where?
court, which is here, the next year, before trial court, in the talk of 31/7 October.
We are now considering a proposition. Just note one of these 4 dates. The original complaint by application by Mr. Ibrahim, that is R3. Then the application by Mr. R5. Then the order of sanction, show cause. Then the sanction order. Then my petition to your lordships and detailed hearing on that. Then 2 days ago counters, and then today's hearing. In between, there is also police complaint filed by us, PCR. None of them mention 31 July. I forgot to mention on 8th of August, PCR is also filed. I'll give you a list
There is no mention about this.
of this. But the mention in the affidavit, which will prevail on pain of perjury, is this, para 55. We have to go by this, not by what is said orally. Since the accused one is the present Chief Minister of Karnataka, the competent authority to accord sanction for prosecution is His Excellency. This is the averment to which this is annexed. The competent authority to accord sanction for prosecution is the Excellency. Accordingly, the complainant has also sought for the sanction and permission from the governor under 19, under 55, under 197, under 218, under 200, which is pending consideration. It is pertinent to note that since the allegations against the named accused persons are not in relation to any action taken or recommendation made by accused one or other named accused, there is no requirement of prior permission of approval from the competent authority under 17A. This court can consider the complaint on merits without any legal impediment. The copy of the same is appended is 35. This 35 is 376.
Yes.
Whereas I counted 6 dates from the first date. again, Malas, I'm not meaning facetiously. There is a saying,
What is
6,
it? This year is 28, all the list of documents are there. There's no 317 here.
give me the date of the application, 2 applications. Whereas in between these dates, write down the dates in a piece of paper. So it's not write it here. In between, on 8th of August, I forgot to mention, a PCR is filed before the trial court. And Malas, that PCR on 8th of August,
That is where you read from. Para 55 is the part of that complaint.
that's right.
Yes.
It's an X there.
Yeah. No, no. Now you read 55
Yes,
at page 43 of the objections. That is
That's
a part
right.
of the complaint itself.
that's right.
PCR.
And it is not, Malas, noted anywhere about 31 July. Stop this.
No, all the documents say there is 317.
And Malas, the document index, what is this volume?
It's the same R4.
Malas, this R4's reply has a list of documents which runs up to Malas serial number 35. You have to see the list of documents. Obviously, I can't show negative. There is no 31 July whisper of a mention.
That's not there.
Therefore, Malas, this by itself, Malas, again, I'm sorry that these are Malas, analogies which are arising from the natural course of conduct done by the respondents, not me. But there's a saying, the first time it is happenstance. Second time it is coincidence. Third time it is enemy action. This is the 6th time, not third time. Therefore, Malas, 17A today on R3 and R4 and R5 has not filed any reply. And I don't have any documents about him. Today, Malas, is clearly. Then, Malas, the 4th sub-aspect of 17A is a very, very strange and quite amazing aspect. The argument is that this offense allegedly took place in Malas, whatever, 2005, 2007, 2010, whatever date you take. Various dates can be. In 2010 or 2005, etc., you cannot apply 17A retrospectively.
That's his submission.
Whereas with great respect, this argument has to be only stated to be rejected. Because if you choose to file a complaint after 10 years, 15 years, or whatever years, and then you have it both ways, I will file a complaint today but not comply with the law of the land today, which is of some, Malas, hoary antiquity already now. Then, Malas, it's an argument which has to be stated to be rejected. These are, Malas, my 4 or 5 sets of arguments on 17A, on which I submit alone, not that this is the only ground, but Malas, alone, this entire thing falls to the ground and should be, Malas, set aside, etc. Now, Malas, the next point I wish to come to, Malas, is to remind your lordships about the statement made by the governor just now, a little earlier, saying that, look, I don't wish to file any reply. Your lordship remembers that we had said that the governor has specific names and dates with investigation, after investigation of Malas complaints pending. And if your lordship will turn to Malas, well, I don't have to give your lordship the note, just note the details, Malas. Annexures from 693 to 696 and 701 to 702. These are much prior complaints, in some of which investigation is complete, charge sheet is filed. The names are, Malas, Sashikala Joli, Murgesh Nirani, H.D. Kumaraswamy,
Charge sheet is
Nardan
filed.
Reddy.
Charge sheet is filed.
Investigation is complete in any
Complete.
case.
Charge sheet is not yet filed.
In one, Malas, I'm told. In one,
Because without sanction, charge sheet cannot be filed.
take out details. What is it? Yeah, but it's investigation complete, therefore a charge sheet is filed subject to the sanction. That is the correct
It is
way.
also filed.
Yes, yes. Yes, yes.
Or-
Today, Malad, when I say that anybody comes to you and you immediately grant, well, the person who granted has at least these 4 names I have given. And the pages are Malad 693 to 695, then 696 and 701. This is an article 14 points straight away, staring you in the face. Now, Malad, there is no reply and none. And in fact, last time orally it was said, orally, that we will let you know about this. Specifically said.
No, he has now also said that he will produce the records completely.
So, Malas, that is, no, but the fact of the, correct, no problem. Records are between the court and there, no problem. But the fact of the matter is that these 4 are actual real human beings, actual real complaints and applications, actual real pendency, much earlier dates, investigations complete. That's all that I'm saying. I don't think the record, whatever is produced, can be different. Now, Malas, the next aspect is another simplest, straightforward point without meaning to over-amplify or oversimplify. The sanction must go. I'll tell you why. Your Lordship has now held absolutely crystal clear that sanction is fully reviewable. That is beyond doubt, the law has gone well ahead of that. It's completely and totally judicially reviewable. The 2 judgments amongst many Amalus, Mansukha 1997 and Yedurappa 2015. My compilation has them. I'll just take your Lordships to them. So it is completely reviewable like judicial review of Malus administrative public law action. Be it Malus for ulterior motives, lack of application of mind, Wednesbury unreasonable, etc., etc. My Lord knows that well. There is, apart from that, Malus, I have given detailed additional law also, and I will Malus cite some of that. Well-established principle. Rameshwar Prasad, State of Gujarat, R.A. Mehta, and of course, very homely flavor of Karnataka, S.R. Bommai. Directly, Malus, they say, it's fully reviewable. I've got the paras also. 9 judges down to division benches. Now, Malus, the beauty of this case is that the governor has not applied his mind or dealt with a single point on the merits of the sanction. I repeat, that's why it's a simpler case. Not applied his mind or dealt with. Whereas you can even deal with the subject, which shows that you've dealt with it without applying mind. It is possible. But for not applying mind, for me to show non-application of mind, I must show that you've dealt with it. The governor has not dealt with a single point. One point he deals with. I am not bound by the cabinet advice. So let me for a minute accept the Honorable Governor and proceed from there. I'm not accepting this, but I'm just saying, please proceed for a minute. You are not bound by the cabinet advice. Let us take it as it is. Therefore, you are acting on a tabula rasa. The tabula rasa is that this man has applied, this application has come.
No, this requires